Today, Kieran McGaughey from Lawyers in Local Government. Kieran is a commercial solicitor, specialises in public procurement and subsidy control, and since 2014 he's worked in-house in local government. He's the National Lead Officer for Procurement Law with Lawyers in Local Government. He's also a director and sits on their national board. Kieran's on the executive committee of the Procurement Lawyers Association and vice chair of its public sector working group. Andrew Millross is a partner at Anthony Collins LLP and co-leads its procurement and construction team, which helps registered providers, local authorities, arm's length management organisations and buying clubs with all aspects of procurement and related arrangements. He also gives advice on improvement and defect remediation contracts, including compliance with the Public Contract Regulations 2015. Andrew's practiced at Anthony Collins for about 20 years, after 7 years in-house in local government. And after specialising in governance and large regeneration projects, including PFI and PPP, most of his work recently is involved helping clients with procurement, development and maintenance arrangements. Andrew wrote the National Housing Federation's Guide to the EU Procurement Rules. Okay, so those are our speakers who I know are going to be absolutely fascinating on the Procurement Bill today. Over to you, Andrew and Kieran.
Sorry. Yes, hello everyone. You're all very welcome to our webinar today. So in terms of format, Andrew and I are going to talk through our thoughts on 6 thorny questions related to the Procurement Bill. Following that, we hope to have plenty of time to field some of your questions, so do send those through using the slide deck feature for that. This is obviously part of the Local Authority LexisNexis and Local Government Lawyer Local Authority Insights series. So in true council democratic fashion, you can vote for the questions you like, so do have a look at that. So the 6 questions we're going to be looking at today in order are: what are the major changes from the EU-derived status quo? What doesn't change? Is the bill likely in practice to provide the greater flexibility the government has promised? What are the key elements for local authorities and housing associations? What remains to be revealed in the subordinate legislation or is generally unclear at present? Is the bill likely to provide, in practice, is the bill likely to provide the greater flexibility the government promises? And last but not least, what practical steps can our authority take now to get ready for these reforms? So first up then, I'm very sorry, Andrew, I'm going to pick on you for this first one. What are the major changes from the EU-derived status quo and what doesn't change?
Thanks, Kieran, and good afternoon, everyone. I think the starting point is to look at where we've come from and where we're going to. So what we have at the moment is 3 sets of regulations: public contracts, utilities and concessions, made under the European Community Act 1972 and kept in force under the Withdrawal Act. We're moving to an Act of Parliament, so we have a bill. There will be regulations under it and lots of guidance. So we're moving style in terms of nature of the legislation. Obviously, an Act of Parliament is harder to change than regulations, so it will be more fixed in stone, and therefore there's quite a lot that's actually pushed down to the regulations and the guidance. We're combining the rules for contracts, utilities and concessions into one document. I thought initially that that was quite a good idea, but having read it and having seen the noise that's around contracts regulations, I'm less convinced that that is such a good idea. What we also have is a fundamentally different drafting style. There's been a real push from Cabinet Office, I suspect lent on by the politicians, to change the language from European language to something completely different. And that has quite a lot of implications for interpretation of contracts. So we know how the courts will interpret some of the concepts from European law. When they change the language, is that intended to change the interpretation? The Cabinet Office says no. As a draftsperson, I will always tell my trainees that if you're changing the language, then you must be changing the meaning. Over to you, Kieran.
Yes, so thanks very much, Andrew. Those are very important points you raised. Something else that really jumped out for me is the new principles and the new objectives of the new regime. So under the current rules, I'm sure everybody could repeat them in their sleep. We've got the four so-called treaty principles of equal treatment, proportionality, non-discrimination, and transparency. And you were talking about trainees there, Andrew. Some sage advice I received earlier in my career was to look at any procurement law query through the prism of those four principles. So taking that on board, I think considering what those principles might look like moving forward is perhaps a good place for us to start when analysing the new regime. So under the bill, what's proposed is a new split. Principles on the one hand, new objectives on the other. So it appears the principle of equal treatment will become same treatment. The Green Paper suggested this would be fair treatment in the government's response. That hasn't materialised. The previous principle of non-discrimination also remains, in my opinion. That's in section 82, but it's not actually listed as a principle or an objective in part 2. Again, the government's response suggests that this would be a principle, so there's currently a bit of confusion as to its precise status. Quite interestingly, transparency will be no longer be a standalone principle, and I find that quite curious. Transparency was one of the key messages of the initial Green Papers, people may recall. So proportionality also, it remains applicable, but now it's only on a specific basis in certain sections of the bill. So to give you an example, competitive tendering procedure must be proportionate, award criteria must be proportionate, but there's no longer a standalone overarching principle. What appears a little clearer then is the new objectives. So those will be delivering value for money, maximizing public benefit, sharing information for the purpose of allowing suppliers and others to understand the authorities' procurement policies and decisions. I thought this was all going to be simpler, Andrew, and acting and being seen to act with integrity. Unlike the principles, then councils and housing associations won't be under a strict requirement to absolutely adhere to those new objectives. However, we will need to have regard to them. And I think an important point to note is those principles and objectives will now also have a wider application in terms of timeframes. They won't just apply to the procurement process, but also through the entire contract management phase also. So certainly for me, that's one of the headline changes that I've observed.
Yes, it's interesting, Kieran, that the section 2 of the bill is headed principles and objectives, and there's a clause in there about objectives, but you have to work quite hard to find the principles. They're dotted about the rest of the bill. They're not clearly set out in section 2. One of the other headline changes is the change to the procedures. So we have some confusion here created by the way the bill's drafted. We have a competitive tendering procedure, which is either the open procedure or an other competitive tendering procedure. So I think I'm going to call that the OCT procedure because it doesn't have any other name. They've badged them both as competitive tendering procedures. In the Green Paper, we talked about having the open procedure and then a separate competitive tendering procedure. It's just the way they've chosen to draft it. And then, of course, we have direct award for things like extreme urgency or technical reasons why you can only go to one contractor. The other competitive tendering procedure is basically a very flexible tool. Flexibility, interestingly, brings risk with it. It's surprising how many procurement challenges relate to light touch regime contracts, social and other specific contracts under the current rules. And that's effectively the kind of regime we're moving to with the OCT procedure. There will be some guidance around it, so it's not left totally up to us. And I'm sure there will be no problem with running an OCT procedure like a restricted procedure. And that's the expectation, that things will be like that. Finally, the procedure must be proportionate to the complexity and the cost of the contract. I'll leave you to work out what that means.
Yes, thank you, Andrew. And you might be waiting a while on that one, but on the plus side, I've remembered to unmute myself this time. So there's certainly lots to get our heads around on those points, Andrew. And I think one of the other points that I see as a headline change is around transparency and notices. So I mentioned earlier, transparency isn't going to be a standalone principle, but that's perhaps gives a false impression, because dotted throughout the bill are new and existing transparency obligations. That manifests itself most obviously in terms of the sheer volume of notices that need to be published under this proposed new regime. I think that's certainly going to be a concern for local authorities around the resource implications of all of this. So, for example, in future, we're going to have things like pipeline procurement notices in certain scenarios, new contract change notices, publishing information about the KPIs you've set, publishing information about contract performance versus those KPIs, new notices about how prompt your payments are, new variation notices. And as I say, that's on top of things like existing award notices, the adverts. Yeah, procurement colleagues on the call, I'm afraid you're going to be very busy under this new regime. Also then, Andrew, I think aligned to that, perhaps, linked to that topic in terms of what information the authority is releasing, we're also going to see changes to the debriefing requirements. Procurement officer colleagues may be happier about this one, because gone will be the mandatory standstill letters that we've currently got under the existing regime. It remains to be seen for me, though, exactly what the new position will be, because the bill essentially says that councils and housing associations under these new rules would need to provide every bidder with something called an assessment summary, setting out information about the authority's assessment of their tender and information about the winning tender. What's just not clear to me, and this may be covered in future guidance, is what does that assessment summary need to contain? Obviously, the time-consuming bit about the current regime is the obligation rather to provide the characteristics and relative advantages of one bid versus the other. So on the face of it, we no longer have to do that, but those who have been following the bill may recall that it was initially proposed that you were going to disclose a full copy of the bidder's tender. So it doesn't seem to align with that previous intention that's now, pardon the word, it's now very light touch in terms of, you're just giving them an information summary. So I think we'll need to follow very closely, Andrew, what will that information summary need to contain?
Yes, I think the information summary, actually, this is one of the positive aspects of the bill, I think. I've always thought there's a bit of a disconnect between the evaluation process, where you're storing a bidder against the award criteria, and the standstill process, where you're having to identify the characteristics and relative advantages. Those two processes don't seem to me to be totally aligned. There's a stage in between, and I think under the new bill, there will be the opportunity to work closer to the evaluation process in terms of the feedback being how the bidder scored against the award criteria, which is, of course, the heart of what an evaluation should be. Another interesting area where there's quite a lot of words in the bill, if I can put it in those terms, are the rules on exclusions, debarments, and breaches of procedural requirements. In other words, the reasons why a bidder won't pre-qualify, or the reasons why a bidder's tender may need to be rejected. I think the debarment list is a good move, because if a bidder's on the debarment list, that is totally clear cut. It's easy for you as practitioners to decide that you can just reject their tender. The problem is we've got exclusion grounds that are beyond the debarment list. So the debarment list is managed centrally by the Procurement Review Unit, which will be part of the Cabinet Office, the PRU, and there'll be a Minister of the Crown decision to debar a supplier with opportunities for appeal. That's all we know so far. We've also got the concept of excluded and excludable suppliers, which roughly equate to mandatory and discretionary ineligibility. The problem is, if a bidder's not on the debarment list, you have to assess whether you think that their misconduct is likely to recur. So if they've been involved in modern slavery, will that recur? And you have to give them an opportunity to make representations to you. So that's more work and more opportunities to challenge. You can also exclude a bidder for improper behaviour. For example, failing to provide information or providing inaccurate information. So if you have a non-compliant tender, you can only exclude here where their non-compliance will give them an unfair advantage. So at the moment, you can say the tender is non-compliant, it was late, Ledbetter and Devon, we're not going to consider your tender. Is there an improper advantage here? You're going to have to think about that. And equally, if a tenderer breaches procedural requirements, you must disregard a tenderer if that's a material breach, but it's only a material breach if it would put the supplier at an unfair advantage. I'll talk a little bit more about that on one of the other questions. Kieran.
Yes, thank you, Andrew. I think that's certainly going to be, a complex area for us all to get our heads around under the new regime. So you spoke about positives there, Andrew. So one area of the bill, which I think is a positive for local authorities, is the apparent increased scope to take account of service user choice when awarding public contracts. I'm certainly no expert in adult social care law, but to me, there's always seemed to be a bit of an inherent tension at the moment between public procurement law on the one hand, where the council or the housing association evaluates the most economically advantageous tender, and we'll come on to that later. And then social care law, on the other hand, which would seem to promote more service user individual choice. So we see this dealt with in the bill in two ways. Firstly, Section 22 award criteria. So as is the case under the current regime, award criteria must relate to the subject matter of the contract. However, and this is the new bit, the reference to a subject matter of the contract is said to include the views of an individual for whose benefit the services are to be supplied, a service recipient, or of a person providing care to a service recipient. So that's the first reference. Also, however, which is quite interesting, the second place where this manifests itself is in respect of user choice contracts, not service recipient, but users. So I'm not sure of the reason for the distinction between the two terms. So hopefully that might become clearer. But anyway, yes, Schedule 5 of the bill sets out direct award justifications. One of those is in respect of user choice contracts. One of the conditions there would be that the contracting authority considers that it's not in the best interest of the individual to award the contract under the competitive procurement procedure. So I think those are two welcome and interesting developments. And you never know, Andrew, they might help to cure that tension that I mentioned earlier.
Yeah. Yes, that does sound positive. One of the areas that's been trumpeted by the government is that around open and closed frameworks and dynamic markets. So closed frameworks, there's basically no change to the framework rules. We've still got a closed framework, maximum 4 years, other than for utilities, which can last for longer, of course. The open frameworks are, I must say, a bit of a damn squib as far as I'm concerned. If you work through the draft bill, there's actually 3 tender processes for a closed framework. There's one at the start of the closed framework, then you have to retender it within 3 years, and then you have to retender it again within 5 years. So why wouldn't you just set up 2 closed frameworks for 4 years each? The only advantage here of an open framework is if you want to keep a provider on the framework for the whole of the period. And that can happen only if either there's an unlimited number of providers on the framework, in other words, it looks very much like a dynamic market, or there's a limited number of providers on the framework, and you evaluate the provider's tender against new tenders at the end of your 3-year period, in your 3-year period and during your 5-year period. The problem with that is a provider might want to update their tender if there's a reprocurement. I can see that's been quite likely. If I were a provider, then I would want to update my tender in 3 years, if only to put inflation on the prices, or possibly to, if things have got more competitive and technologies made things easier, to lower my prices. So I think that is probably a bit of a dead duck in terms of the open frameworks. Dynamic markets are very much like a dynamic purchasing system, rebadged. There's no limit on what a dynamic market can be used for. Well, theoretically, dynamic purchasing systems are meant to be used for commonly used purchases, but I've seen them for responsive repairs, voids, legal services, simple things like instructing lawyers. So I think the rules are just legitimating here what is happening in practice. There may be a little bit more flexibility here in a dynamic market. There may be opportunities for using a dynamic market in a way a bit like a purchasing catalogue with electronic catalogues without the need for a tender process. So there's a bit more flexibility here. One of the things that I commented on in my response to the Green Paper was I thought that there was a fundamental conflict between a buying club charging fees to suppliers, because actually there's an incentive on the buying club to maximize the amount payable by the client under the contract to maximize their fees. Sadly, the Cabinet Office took the opposite view, and they have legitimated the ability to charge the rebate. They put it in clearly, both for framework agreements and dynamic markets. Kieran.
Yes, thank you, Andrew. So I think we're possibly coming to the end of our time for the first question. So we'll just finish up quickly with some observations on that. So one of the points I wanted to touch upon quickly, Andrew, was around contract variations. That's obviously an area, you know, us lawyers get asked to advise on very regularly. So currently, the rules are set out in Regulations 72 of the Public Contracts Regulations. Under the bill, they're going to be in Section 69, but also in Schedule 8. Given when you mentioned earlier, Andrew, one of the whole points for this reform is to consolidate the law into one place. I do find that quite frustrating in terms, you know, we're going to have to be looking in two different places. So one of the plus points perhaps is there are new additional grounds. One of those is materialization of a known risk. What I don't really understand with that, though, is why that possibly just couldn't have been dealt with under the existing regime in terms of clear, precise, and unequivocal review clauses. I must say, I don't think anyone's ever described my drafting as clear, precise, and unequivocal, but that's a story for another day. One of the other new grounds is in cases of urgency and protection of life, that can allow you to make a permitted modification. And there is a narrower definition of what is a substantial modification. So that's possibly more flexibility. One of the downsides, I think, however, is that the new wording around a variation being substantial, if it increases or decreases the term of the contract by more than 10%. So under the current rules, there is provision for, I think it's something along the lines of where the modifications, irrespective of their value. So it does seem to be there is now a value cap that wasn't there previously. So this will require careful exploration in future. But anyway, Andrew, I will hand over you to wrap up our first question.
Yes, on the variations, we're about to issue an e-briefing on our website on the new variations. So that shall probably come out next week, depending on the speed of our marketing team. The other significant change is there are some changes to the TECAL rules. I think that those are mistaken emissions, and I'm hoping that they will be changed and corrected during the passage of the bill. The first and obvious one is there is no multiple TECAL, so you can't have joint controls, which has major implications for collaboration arrangements. And the other one is a change of wording. At the moment, for turnover to count, it must be in the performance of tasks entrusted to the subsidiary by the parent. The change of wording is to say for and on behalf of the parent, which suggests much more of an agency type, closer relationship is required. And therefore, that has major implications for certain housing association group structures. We've already issued an e-briefing on that. That's also on our website. So, Kieran, I think we're on to the next question.
We are indeed. Thank you, Andrew. So the next question then, how does the bill differ from the green paper published last year? So for the last question, I'll puck on you, Andrew, so I'll go first this time. So I think the first point that occurs here is the light touch regime is going to be retained. Those of you who've been following the consultation process will recall that originally last year, the intention was to abolish the light touch regime, consolidate those contracts into just a single set of regulations. So I think that's good news for local authorities. And I would commend those of you from local government bodies who did take the time to respond. Clearly, the government have listened, so that is welcome. Given one of the stated aims of the new regime is to be more flexible, that for me is a sensible policy decision in terms of retaining that flexible light touch regime. What we don't know yet, though, is exactly what contracts will form part of the light touch regime. That remains to be seen, and I think that will be covered in future regulations. So the second point then that occurs to me here is the proposals around procurement challenges. Those have also changed. Again, I think there's some good news for local authorities, perhaps some less welcome news. We'll go first with the good news. There won't be a tribunal for lower value disputes. I think some councils I spoke to were concerned that if challenges were, cheaper and faster, then we might face more challenges. On the flip side, you may recall there was a proposed cap on damages that could be awarded to a challenger who had brought a procurement challenge. That proposed cap has now been removed. So the position remains as is, really, in terms of local authorities do face, greater exposure, but in line with the current regime. Andrew, over to you.
Yeah, there's also been some pulling back on the volume of notices, but having stoked the number of notices, there's quite a lot more pulling back that needs to be done. We've still got pipeline notices, planned procurement notices, preliminary market engagement notices before we get to our equivalent of the tender note, the contract notice, which is the tender notice. We've got two contract award equivalent notices. So we've got a contract award notice, which is the standstill notice, then a contract details notice, which equates to what is the contract award notice at the moment. That's the one you post when you've signed your contract. We've got a procurement termination notice on discontinuation. That's fair enough. We've got a payment compliance notice, 2 of those per year. Specified information about any payment of £30,000 or more under a public contract. That's going to be a real paper chase for high value construction contracts, because most payments will be over 30,000 on a monthly basis. Published information about KPI performance, contract change notice, and a contract termination notice. So although there has been some pulling back on the volume of notices, there's still quite a lot there that we need to do. There's been a couple of surprises. The biggest surprise for me was the compulsory KPIs clause. That wasn't trailed in the green paper at all, that contracts valued over £2 million must include key performance indicators, at least 3 key performance indicators. There's nothing that says that the regulations will give you an indication of what those KPIs should be. So it seems as though you have a completely free choice over what KPIs you set. So we've been talking in the office about the most ridiculous KPI we can come up with. So our latest starter for 10 is the number of tradespersons wearing brown shoes on a Tuesday morning. That's the proportion, and we can set a target for that and measure it and publish our information. Seriously though, I think it needs to be about contractor performance, but there is a lot of sort of misunderstanding of the use of KPIs. KPIs are brilliant on term contracts where you've got an ongoing service. For project contracts, what's the point of setting KPIs? You wouldn't want to sack your contractor halfway through a construction just for poor KPI performance, or would you? And
Yes,
I think I start off on the next question as well, Kieran, don't I?
yes, I was just going to make sorry, Andrew, I was just going to make a very quick point regarding the KPIs. So it does say in section 52 the requirement does not apply if the contracting authority considers that the supplier's performance under the contract could not appropriately be assessed by reference to KPIs.
Yes.
And I do wonder, Andrew, if a lot of councils might look to, to tag on to that. But look, we'll see.
Yes, I think the issue here is appropriately and what that actually means in practice. But let's move on to the next question. What are likely to be the key elements for local authorities and housing associations? For housing associations, I got quite excited when I first saw the definition of contracting authority, because it refers to an authority. So I thought, well, what does authority mean? Doesn't sound like a housing association to me being an authority. Sadly, there's a definition of authority being any person. So it should have said any person exercising public functions of a public nature. Why put an intermediate term in and then define it in that way? Poor drafting, I must say. Not something I would allow my trainees to get away with. But the more important point is that an authority has to be an organisation exercising functions of a public nature. An explanatory note here refers to building roads or policing. Now, is the provision of social housing a function of a public nature? We got the courts going different ways on this. So at the moment, housing associations aren't subject to freedom of information legislation. They are subject to judicial review for certain decisions. They're not part of the national debt for statistical purposes, but they are contracting authorities under the current rules. I think this is one where the Cabinet Office have basically recognised that they've made a boo-boo. We've heard that the Cabinet Office is not intending by this change of wording to change the definition. But the question is, having made a boo-boo, what are they going to do about it? Are they going to try and fix it by guidance, or are they going to correct the bill? Because if they try and fix it by guidance, then the courts will look at the guidance, but this is UK legislation. It's not purposive European legislation, and therefore needs to be interpreted by the courts as UK legislation, deriving the meaning of the words from the words used rather than extraneous materials. So there may be a real opportunity here for housing associations to say that we are not subject to the procurement rules. That will be a very interesting case to take to the Supreme Court, depending on whether the bill is changed and sorted. Kieran.
Thanks, Andrew. Yes, that's an excellent point about contractual interpretation. That's going to be tricky areas in terms of some of the current wording. So one of the key elements that I see then for councils is being the need to prepare for procurements earlier. So, you rhymed off there, Andrew, a whole host of notices. So for example, those procurement pipeline notices, if your council expects to pay more than, I think it's 100 million on procured contracts over the coming year, you'll have to publish these notices. Now, I would imagine that's going to, grab a whole host of councils on the call in terms of those obligations. If we're using the new competitive tendering procedure, then you would have to take stock at the beginning rather and design a bespoke process rather than, one of the previous off-the-shelf solutions. Not only design your process, but also ensure the actual tender documents then reflect that. There'll also be the need, although there is also at the moment, to take account of the National Procurement Policy Statement, but that will be on a stronger statutory footing in future. We'll also need to consider what KPIs are appropriate. Are those KPIs in the contract terms? And there'll also be other new commitments, like, for example, a more formalised conflict of interest assessment. So those are some of the likely to be the key elements for local authorities is resources and workload, in my opinion.
Yes, there's also going to be quite a lot of work around running tender processes. So the practicalities around exercising discretions, around exclusions of tenders, non-compliant tenders, and potentially challenges to those discretions. So you're going to have to make judgment calls on whether an excluded supplier is likely to re-offend, or whether a late or non-compliant tender has given the tenderer an unfair advantage. That leaves you with quite a lot of difficult decisions. So if a tender is 5 minutes late, does the supplier receive an unfair advantage by those 5 minutes? What about 10 minutes? What about half an hour? An hour? Where's the cutoff point? At the moment, it's very simple. Under Leadbitter, you're late, you're excluded. Under the new rules, these discretions and the need to give opportunities to make representations, I'm afraid this is potentially a major area for challenges.
Yes, thanks very much, Andrew. So I think we'll just move on to our next question then, Andrew. And I think, sorry to pick on you again, you're up first.
So that's me. So what remains to be revealed in the subordinate legislation or is generally unclear at present? I think you've probably gathered from what we said so far that there's quite a lot that's unclear at present. But it's not only subordinate legislation, it's also guidance, it's updated documents, it's PAS 91 and the selection questionnaire, or the SQUID if you're in Wales. It's the National Procurement Policy Statement. We haven't seen a draft of that. We have a National Procurement Policy Statement, but is it going to change? The Welsh Procurement Policy Statement. Section 12 and 13 talk about a duty to have regard to the National Procurement Policy Statement. So my understanding of the have regard wording comes from the London Oratory case, which means you need to follow it unless you've got a good reason not to. We're waiting for some regulations on the content of notices, the form of notices. So there's quite a lot around subordinate legislation, regulations, guidance, PPNs, policy statements, and all the documents to support that.
Yes, thanks very much, Andrew. So from my perspective, in terms of that question, what remains to be seen, something which is very unclear, I think, is how this new competitive flexible procedure will actually work in practice. Just a recap for viewers, we won't have the restricted procedure in future. We won't have competitive dialogue. No competitive procedure with no negotiation, no innovative partnership procedures. So whilst local authorities, in my experience, tend not to use those procedures a lot, apart from, maybe the restricted procedure, we do need to know what we can do under this new procedure. So there's a clear gap at the moment in terms of guidance. And, you would really hope that's filled in, secondary legislation and, statutory or non-statutory guidance. Another interesting point, Andrew, I know it's a bit of a hobby horse of ours, is Section 17 of the Local Government Act 1988. So people on the call will recollect that this prevents local authorities from taking account of so-called non-commercial considerations when making decisions about awarding contracts, terminating contracts, things like this. Obviously, that's really reared its ugly head again this year in terms of Gazprom and the Russian linked state suppliers, and local authorities really caught between a rock and a hard place in terms of possibly wanting to terminate those contracts. So under the bill, we see at Section 104, disapplication of duty in Section 17 of the Local Government Act 1988. So I got very excited, Andrew, when I read this, but then when I read on, they aren't actually disapplying it. They're just kind of, paving the way for possible future regulations. So I see you nodding there, Andrew. I think we're hopefully agreed that whilst we're moving on the right direction on this point, we would want a full repeal.
Absolutely. The sooner the better. They seem to be sitting on the fence over repealing this. So we've had it disapplied for, obviously we had it disapplied for best value some years ago. We've had it disapplied for the Belarus and Russian contracts by some regulations. So they seem to be looking to disapply it piecemeal. There is an opportunity to repeal it by secondary legislation, but why don't they just bite the bullet and do it in this bill? It would be far simpler. And if simplification is one of the objectives, let's encourage them to simplify and get rid of this this provision, which actually prevents local authorities from acting ethically and looking at in a way that we would want. Certainly, I would want local authorities to be able to act. I think it's time to move on to the next question, which is the bill likely in practice to provide the greater flexibility the government promises it will? And what we have here is the government trying to pretend that they can have their cake and eat it. We have a tension between flexibility and simplification. If you have one size fits all, there is no flexibility, but life is very simple. And life is very simple in terms of SMEs knowing what the rules are, knowing what everyone's tender process is. You can have a standard approach to exclusions, debarment, all those kinds of things. Simplification has lots in favour of it, but it doesn't give you flexibility. As soon as you start to introduce flexibility, you increase complexity and you have different things. So you don't have standardization, and standardization provides for efficiency. Flexibility gives for choice. It gives local discretion. It allows you to tailor your procurement to what you're procuring, but it means suppliers could be faced with different requirements, different kinds of things that they need to put in their tenders, different ways of pricing. You can have target cost contracts, cost reimbursable contracts, price per property, any number of payment mechanisms, which means that flexibility is great in terms of procuring different contracts different ways, but it does add complexity. You can't have both. There's a choice, and there's a dividing line to be set in the bill.
Yes, thanks, Andrew. And I think whilst we're talking about flexibility, another change which might generate greater flexibility is that meat will meet MAT. Now, if people are wondering what the hell I'm talking about, they will recall that under the Public Contracts Regulations 2015, the councils are required to evaluate bids on the basis of the most economically advantageous tender, MEAT, meet. Under the bill, however, you may have noticed we'll lose the word economically. Instead, it just becomes MAT, most advantageous tender. So this hopefully sends a clear message to councils and housing associations and others that, you know, non-price factors such as social value can be considered. What I would say on this point, though, Andrew, is that in practice, it's arguable as to how much change there actually is, because, you know, we already see over recent years an increased focus on social value under the current rules. I'm thinking of things here like, you know, the social value model, the carbon reduction plans for central government. So I also don't expect, to be honest, cash-strapped local authorities are going to stop worrying about price anytime soon. So I think it's perhaps a message here that will promote the flexibility rather than necessarily the law changing much in practice.
Yeah, I agree with you. I think the change possibly represents a misunderstanding of the flexibility you have with meat. The other point to note is that one of the principles is value for money, and I don't think you can follow a principle of having value for money without taking at least some account of the economics of the so you need to focus on both the value side and the money side. It's just sending a message. I think the only change that this might allow is things like clever average value pricing, where you evaluate tenders as to how close they are to a set price set by the authority, rather than evaluating tenders whether they're lower than other tenders. And finally, in terms of our questions, what practical steps can our authority take now to get ready for the reforms? I think the first point to make, it is likely that there will be substantial changes made to the bill during the committee stage. It's interesting to see, I've looked at the House of Lords marshalled amendments, and the bill has generally been welcomed by the politicians on all sides and slated by the practitioners on all sides. So we have a danger that the politicians will regard this as positive and the practitioners will regard this as unworkable. So we have a tension and a lobbying job to do to try and make this bill workable. The other factor is that there will be a need for additional procurement resource. So the sheer number of notices that will need to be published, the number of judgment calls that will need to be made, the requirement to invite representations from bidders, the need to publish copy contracts where they're valued over £2 million, not just make them available, to actually publish them. So someone is going to need to be going through those contracts and redacting every contract over 2 million, not just those where you're thinking you might get a Freedom of Information Act request, or where you are asked for a copy contract under Regulation 83. Kieran, what else?
Yes, thank you, Andrew. So in terms of our final question, then, what practical steps can an authority be taking? From my perspective, these are some of the points I would encourage our viewers to be looking at within your authority. So I think look at setting up an internal working group with, various stakeholders, legal and procurement being the obvious ones. Start thinking, identify what needs done, dividing up tasks, timescales. The Cabinet Office have provided a clue as to what the training program might look like, and there'll be different levels of user, different levels of training. Perhaps start having a think within your authority, in terms of who's going to be the super users or really undertake the most advanced training. In terms of documents that will need to change, contract procedure rules, standing orders, contract terms, for example, to take account of those KPIs Andrew spoke about earlier. Or for example, current contracts often relate to Regulation 73 in terms of modifications that will change. Invitations to tender, Andrew talked about the new procedures earlier, that will all need to change. There'll also be this new evaluation basis of MAT instead of meet. That will all need to be reflected in your procurement documents. One of the other things to possibly consider is, obviously we're now required to consider the National Procurement Policy Statement. You may wish to consider setting your own local priorities document and, having regard, as Andrew talked about earlier, to that alongside the national priorities. And finally, I think communication is an important one. Ensure people are kept updated. It's probably quite confusing at the moment. We've had the green paper, the response, the bill, the current rules, the new rules when they come in. Make sure people understand that, as of today, nothing has changed really, and, keep it on their radar as to when change is likely to happen, and, embrace that change and be on the front foot. Get management buy-in. I think that's an important one for the reasons Andrew spoke about. This is all coming down the track with associated resource and cost implications. And do also sign up to some of the Cabinet Office updates. Andrew mentioned earlier the Anthony Collins updates. They're very good. Lots of our LLG corporate partner law firms specialize in procurement. Very useful webinars, hopefully like this one. And if I can give a quick pitch, you can also join our Lawyers and Local Government Procurement Law Group. That's entirely free, and we send out, briefings and also organize events like this. So Andrew, I think that is the end of our time, and we've done all right. And perfect timing there is Carl. Hello, Carl.
Hi, thank you, Andrew and Kieran. We may have time for a couple of questions, I think, if we can. I hope we'll be able to see them on the slider in a few seconds. That's brilliant. Okay, should we start at the top then, which asks about proportionality and transparency? It's odd, the question says, Paolo, that proportionality is kept, but transparency is not in the bill. Do you think the expectation is that integrity would encompass transparency? Do you think?
Shall I go first on that? I mean, the honest answer, I think, is none of us know, because we don't know how the courts are going to interpret this. But my view is not, in the sense that I think transparency, the Cabinet Office is trying to weave transparency round the other provisions of the bill. So integrity means probity. Is how I would view that. So acting properly, treating suppliers fairly, not pulling a fast one, that kind of thing. And I wouldn't see transparency as part of that. It's close to it, but it's not quite the same. Transparency, I think, is weaved elsewhere in the bill. Kieran, what do you think?
Yes, Andrew, it's probably the safest option, but I'm going to agree with you. And I think for one of the reasons you spoke about earlier is obviously under, domestic British law, we don't really look behind the meaning of words. We don't take that purposive approach. So, integrity on the face of it, as you say, it doesn't mean the same thing as transparency. It's perhaps a related concept, but it's not the same. And the only way I could see transparency being incorporated would be if some of this deluge of guidance we're expecting said that was the
Yes.
case, but I must admit I don't expect that to be the case, and I would expect if transparency was going to be an obligation that would have been expressly set out. But look, do watch this space. Lots of proposals being tabled in terms of amendments to the bill, so who knows, we might end up back with transparency.
Yes. I think the next one's probably one for me, isn't it, given that I was talking about non-compliance and unfair advantage. So I think that what we're looking at here is clause 30, which said, and that's titled excluding suppliers for improper behavior. So we must treat a supplier as an excluded supplier if the suppliers acted improperly in relation to a procurement. So trying to negotiate afterwards when there's no scope for that in the procurement process, I think could be regarded as acting improperly. In consequence, the suppliers put at an unfair advantage in relation to the award of the public contract. And the unfair advantage cannot be avoided other than by excluding the supplier. So I think you've got some judgment calls around this, haven't you? So your supplier tenders, then accepts the contract, and you say any supplier refusing to accept the contract terms will be excluded, then tries to negotiate those contract terms later. I think your question is, would that put the supplier at an unfair advantage? And that's going to depend on the nature of the negotiation. So it's not that different from what happens now in terms of post-tender negotiations in practice. I mean, we all know that post-tender negotiations shouldn't happen in practice. We all know that they do happen in practice, and there's always a judgment call. Would that those changes have changed the result of the procurement? What's the risk of challenge? All those kinds of questions. You're back into judgment calls.
Yes, completely agree with that, Andrew. And I think, as you say, that is one of the issues really with the current regime is, there's very little room for maneuver in terms of, for example, if you're running an open procedure and you've got the contract terms published and you do want to change them. So, or, more likely a bidder wants to change them. What I'll be interested to see is whether there'll be increased scope in this new competitive flexible procedure to have those sorts of negotiations and how that will be framed. What I do think, though, I almost said equal treatment here, but we do have this new obligation of same treatment. And I think that's potentially the tension in terms of how do you maintain same treatment when one bidder is saying, yeah, look, we'll do it, but we don't want a liability cap. Someone else is saying, yeah, we'll do it, but we can't agree that indemnity. How do you maintain that same treatment? So I think that's going to be one of the difficulties. But look, again, watch this space.
Yes.
Okay, the next one I think is about the loss of proportionality and other principles or overarching principles. Will that cause issues? What do you think of this?
So can I sort of just make a comment on this? So my starting point was I'm quite a traditional lawyer. I quite like hard law in terms of knowing where I stand. And it's quite strange that I'm actually practicing in a European field where principles and proportionality and all those sort of soft interpretation requirements actually impact on how you interpret legislation and all the case law. It makes it interesting, but I'm greatly in favour of clarity in terms of contracting authorities knowing exactly what they have to do, knowing what the parameters are, knowing what flexibility they have. And the more you introduce concepts such as proportionality, principles, equal treatment, same treatment, the more discretion you have and the more you have to work quite hard to know where you stand. So I'm, despite having been in European law for sort of 25, 30 plus years, not too worried about the loss of proportionality and some of the other principles. Kieran, what do you think?
Yes, I must admit, I'm possibly a creature of habit, but I do have those 4 procurement principles ingrained somewhere in my brain. So, there's going to be a period of, readjustment, trying to adapt to the new ones. I do entirely agree with the person that's raised the question in terms of they are quite useful. A client asks you a question, can we change something? Can we push a deadline back, and you are thinking, is this proportionate? What I would say, I think I possibly touched upon it earlier, is, that there still will be proportionality in places. Off the top of my head, I think timescales is one, but it is certainly going to be difficult. And another point on this topic is that all these principles and objectives now apply throughout the procurement life cycle, including the contracts. That's going to be a potentially difficult one, Andrew, in terms of, say, for example, you're making a decision to terminate a contract. You wouldn't always usually at that stage be looking at, is this equal treatment? Is it proportionate under the old rules? But under the new rules, you will have a greater series of factors to consider in terms of making those in-contract decisions. So I think it is going to potentially cause issues, certainly going to be more complex in my view.
Yes. And the last question, I think, again, is one for me. All I'd say is if you want an annual framework agreement, you can do it under the current rules. You can retender it every 12 months. It doesn't have to be a 4-year framework. Why don't you retender it as a closed framework? If you want the supplier to stay on the framework, then the open framework rules might be useful for you. But remember, the only way that they can stay on the framework is if either you don't limit the number of suppliers on the framework, in which case you may as well set up a dynamic market, or you evaluate that supplier's tender for the initial framework competition every year against the new framework suppliers tenderers, the new tenders, and they only stay on the framework if their tender falls within the number of places you got on the framework. Why wouldn't they want to update their tender on an annual basis? So you can do it now. I don't think it gives you anything, the open frameworks.
Oh, okay. Anything on that, Kieran? Or
No, I wouldn't be brave enough to disagree with Andrew, to be honest with you.
Fair enough. Fair enough. Well, the 1 o'clock bell has rung, and so I think we've come to the time when we have to close the webinar. Thank you to Local Government Lawyer. This webinar has been produced in association with them. Thank you, Kieran. Thank you, Andrew, for brilliant insights into the Procurement Bill. Thank you all for attending. You will receive a recording of the webinar when it's available. Thank you, everyone.